From the opinion pages of the Wall Street Journal, this is Potomac Watch.
A federal judge rules that the Biden administration illegally pressured social media platforms to censor certain views it didn't like, especially on COVID-19. And the judge bars administration officials from meeting with the social media platforms. How significant is this case for the future of free speech and the government use of private actors to do what the First Amendment bars government from doing? Welcome. I'm Paul Gigot with the opinion pages of the Wall Street Journal, and I'm here with my colleagues Alicia Finley and Kyle Peterson talking about this case, which is Missouri v. Biden. We're now in federal district court. Alicia, tell us about the background of this case. Who sued the government and what are they claiming?
So Louisiana and Missouri, the states, they sued actually various government officials. There are over a couple dozen and various government agencies, and these include CDC, Census Bureau, FBI, the HHS, and some of the officials that were named were Anthony Vucci, as well as Rob Flaherty, who we can get to in a little bit, who worked at these agencies. And what the states and also some scientists or leading plaintiffs were authors of the Great Barrington Declaration in 2020, which was censored by many of these platforms.
Which took an alternative view of how to handle the pandemic.
Right. One of the other plaintiffs was the owner of Gateway Pundit, whose posts had been censored by some of these platforms. And they alleged that the platforms, again, Facebook, YouTube, Twitter being the primary ones, were censoring or removing, in some cases, deplatforming individuals at the behest of the government, and that the government and these government agencies and officials were coercing or, quote unquote, encouraging the platforms to boot them or suppress their speech.
It's fascinating because, of course, the private companies themselves are not subject to the First Amendment per se. The First Amendment constrains government actors. The private companies also have liability protection under Section 230 of the Communications Decency Act. So why are the private actors acting on behalf of government here? Why did Judge Terry Doughty find that there was this pressure on them to do the censoring?
So he looked at, actually, this was a very facts and evidence specific case, and he examined the evidence and a lot of these communications between the government agencies or government officials and the platforms, so the Twitter and Facebook employees. And he found that they were, quote unquote, significantly encouraging or coercing the private platforms to do their bidding. This actually gets to 1982 precedent Blum, which related to actually nursing homes and whether the government could be liable for essentially coercing nursing homes to violate law.
I see. So this is basically, he went through a lot of discovery. It's the first time these emails and other communications have actually been coughed up in a case like this. And he looked at that evidence. And what did he rule? What did he decide?
Well, he ruled that they had violated the free speech rights of the plaintiffs, and actually said that they probably violated the speech rights of the millions of Americans across the country. And by the way, they decided to restrict certain content that the government disliked, disfavored, and that this speech was predominantly conservative views.
And on COVID, it was dissenting views from the orthodoxy of the government on lockdowns, on vaccines in particular, and other things, right?
Masks, right. And those were the three big ones. I think the strongest evidence in the case actually really concerned the vaccines. And that's where you really saw the Biden White House officials put a lot of pressure on Facebook and Twitter and YouTube to take down content that flied in the face of their official guidelines.
Kyle, what's the coercion that is supposedly exercised here by the government? Obviously, the government has its own right to talk to private actors. It can say, we don't like this policy. That's not coercion per se. What is the coercive element here?
It's communications between members of the government and staff for these social networks. So here's a couple of examples.
But what makes it coercive? Because if they just say, call up Kyle Peterson and say, Kyle, I don't like that editorial you wrote, you're going to say, well, thank you very much for your comment, but I don't care.
Yeah, I mean, so here's a couple of examples. Quote, cannot stress the degree to which this needs to be resolved immediately. Please remove this account immediately. Here's another one. Internally, we have been considering our options on what to do about it. And there was some talk at that point of revising the Section 230 immunity that social media platforms enjoy in the law.
This is the government threat against the companies. We're tugging our chin and saying, we're thinking about revising 230, which protects you from liability.
Right. And so the judge's view is that it's a little bit like nice social network you have there. Shame if something would happen to it. Here's what the judge says is the standard. The state can be held responsible for a private decision only when it has exercised coercive power or has provided such significant encouragement that the choice must be deemed to be that of the state. So basically saying that Facebook, Twitter, these social companies had no choice but to comply with these requests. I would push back a little bit, though, because maybe that is true, in particular with regard to some of these communications between the social networks and the White House. But if you go through and look at the exhibits, the discovery that was found in this case, a lot of this looks like places where people at the social sites that were concerned about misinformation and people in government who were concerned about that were working together. So there's a White House email, for example, that flags an Instagram user, Anthony Fauci official, and says, any way we can get this pulled down, it's not actually one of ours. The answer from Facebook is, yup, on it. So there's a case where Facebook has an incentive, I think, not to have people masquerading as public officials on their platform. The White House obviously doesn't want that either. And so they're kind of working together. And the same is true for some of the COVID stuff, at least. You have emails between the CDC and these social sites where the social sites are saying, like, we're seeing all sorts of claims that COVID vaccines might cause ALS or magnetism, or that they can alter blood color. Can you verify whether this is true or not? And the CDC says there's nothing to this. Or in the examples of like myocarditis, yes, there is something to this, and trying to respond. And I have a hard time seeing how there's coercion in some of these emails, at least.
Okay, fair enough. I mean, conversations like that are not coercive. But if you start to say, as a government official, that Section 230 thing, we may want to revise that. Please excise this content. Oh, and I gather, Alicia, there's also some antitrust threats here that were part of it, correct?
Right. Then the privacy regulation, which the giants have also been trying to ward off. And to the antitrust point, Facebook has already been sued. The FTC is trying to break up Facebook. And actually, it's continued to go after Facebook with a number of lawsuits. And actually, for that matter, the Justice Department has also sued Google, numerous antitrust claims,
which owns YouTube.
Right. So this threat was legitimate. And I think going back to the point on Section 230, what's interesting is the Biden administration tries to claim in its defense is, well, there was bipartisan support from Congress. And so that threat, it's not legitimate, or it doesn't really mean anything because Republicans support modifying or revising Section 232.
Did the government actually say that?
Yes, they actually made that in their defense.
Of course, that
makes it even more likely.
Yeah, it makes it more likely that they'd be able to follow through on the threat. So, Kyle, what is your response to that? These are government actors, the White House being a very powerful government actor with control over Justice Department, with heavy influence over the federal agencies. Why would it not be coercive in that case?
Well, it could be, and that's the question. I mean, it will be fascinating to watch this as it works its way up the appeals courts and maybe to the Supreme Court. I'm certainly open to the idea that particularly these White House statements that I quoted, that sounds a little coercive to me. One question in the case would be how far that goes down the chain of government. I mean, if somebody in the White House advisory team is saying coercive sounding things to Twitter, does that affect these good faith interactions between the CDC? Does that coercion go all the way down the government chain of command, as it were? But that's part of why I think this case is so interesting, worth watching, is we have a new form of media, social media, and we don't have a great case law, nothing really analogous to these situations to rely on. And so we're going to answer some of these questions. And I would point to another piece of the judge's ruling. So he says he barred certain communications, interactions between government officials and these social sites. But he says the following actions are not prohibited by this preliminary injunction. One of them is exercising permissible public government speech, promoting government policies or views on matters of public concern. So is it the secrecy that was the problem here? If these White House officials said publicly, we think X is misinformation and we're disappointed that Facebook is not taking greater action, is that coercive in the same way that private conversations to the same effect are? And then two, the judge also says that not covered by his injunction is informing social media companies of postings intending to mislead voters about voting requirements and procedures. And I'm a little bit flummoxed by that, because if these interactions are coercive with regard to COVID information, I have a hard time seeing how they're not coercive with regard to what people are saying on voting procedures.
All right.